So having established what is a meeting, or at least having established the gray areas of what is a meeting, let's talk for a minute about what doesn't constitute a meeting. The Baggley-Keene Act recognizes that there are lots of gatherings where a quorum of a body is going to come together, and that's not going to result in a meeting. I'll highlight some of the exceptions, but I want to point out first that the exception for these events is dependent on a couple of things. There can be no discussion at that gathering of matters that are within the board's jurisdiction. So if the dialogue shifts and you begin to have a quorum that talks about some matter that is before it or could be before it, then you're going to lose this exception, these exceptions that I'm about to mention. The first is the conference exception. There's an exception for conferences. A couple of requirements that have to be satisfied. The conference has to be open to the public. Now, if the conference is a closed conference, even if it's open to a larger group than the body at issue, that's still not open to the public. So this exception only applies if the conference is open to the public. It also has to be on matters that are within general interest of either the body. Sorry, yes.
That provoked a number of questions. Yeah. So open to the public, does that mean it has to be free? What if it's a conference, you know, a paid conference on, for instance, real estate?
That's a great question. Yeah. I don't know the answer to that off the top of my head. Gina, do you?
Yeah, I think if it's paid, but anyone can pay to go, then it would be considered a conference and within the exception.
So the other one that I have to be careful about is meeting, for example, a conference of actuaries, where I happen to meet with more than a quorum of my fellows on the California Actuarial Advisory Panel. That then is that a public meeting? I believe it is marketed to actuaries, but I don't believe you have to be an actuary to sign up. So it's not real clear how public that is. It's really a conference for actuaries, but I believe certainly members of the press can attend. I don't know about. I don't think they'll refuse the $1,000 fee to go to the conference to anyone.
Yeah, you want to answer that?
Yeah, but the California Actuarial Advisory Panel is covered by Baggley-Keene, so
yeah, we should probably talk about that offline. That's not calPERS.
What?
Okay.
What about something like the NC-PERS meeting?
I'm sorry?
The NC-PERS, National Council of Public Employees, or Public Employee Retirement Systems, would that, and obviously if you're going there, people are going to ask you about things within the scope of PERS and you're going to talk about, would that create a...
Yeah, I don't know enough about that group to say that they're open to the public, but insofar as that it's not a closed group, it's an open group, but it's a group of specific interests, I don't think that makes it a closed group, just because and it would also be a group where it's got the topics are of interest to bodies like calPERS. The second piece of your question goes to whether you can say anything at all, and I think it would depend on who's there. If you have a quorum of the board there, and each of those people are lending to the conversation in a way that discusses board matters, then you're going to cross the line. But if you're not talking about board members or you don't have a quorum at that conference, then you don't have a problem.
Just one point. We tend to err on the side of better safe than sorry. So when we know that we're going to have potentially even potentially a quorum of the board at a given conference, we'll send out a public meeting notice on that just to be safe. So, there's some things that we can do to try to get ahead of issues.
And are we making sure that, because it's not just quorum of the board, it's quorum of a committee of the board, so some of the committees are fairly small, so are we managing to that as well in regard to quorums?
I believe so. I think Peter looks out for that, and whenever he gets to, you know, some critical mass, and I'm not sure what number he uses, but my suspicion is if he thinks that there's going to be 3 or more board members anywhere at a given time, it's just easier to notice it. Ann?
Yeah, I mean, I would just rest assured our board president and Mary Ann, they're on top of it. They know which board members are going where, and they contact us right away if they think there's any issue. It rarely comes up that there's a quorum of board members at one of these industry conferences, so thank you.
Okay, a couple other examples are participating in another body's meeting, ceremonial and social events. And there's several others that I'm not going to cover that are identified in the Act that fall under this exception. But again, the key is to not let the discussions, especially when you think of something that might be social, to not let those discussions evolve into something that's within the jurisdiction of any of the bodies that you sit on. So having covered now what is a meeting, what's not a meeting, we're going to talk about a third kind of meeting these are within the scope of Baggley-Keene, but they're permitted to be held in closed session. And so they're not required to follow the requirements in Baggley-Keene that they have to be open to the public and all of the other pieces that go along with it. That said, they are still subject to some Baggley-Keene requirements. So closed session meetings have to be noticed. And in fact, the notice has to identify what the meeting is and the topic, and also the authority for holding it in closed session, which all of you are familiar with because that's calPERS practice. The organization is also required to keep minutes of closed session meetings. So they're not entirely outside the scope of Baggley-Keene. Before we talk about the specific exceptions, I want to note that the closed session exceptions are narrow, and courts have construed them narrowly. The Act provides an exclusive list of what can be held in closed session. There's no sort of catch-all provision the way there is under the PRA and other laws that might bring anything else that would make sense to be held in closed session. There's nothing like that. It's an exclusive enumerated list of what can be held in closed session. I'm going to talk about just a few of the items that may be held in closed session, not all of the exceptions. First is the pending litigation exception. And the purpose behind this exception is to allow dialogue between the body and counsel on matters where, if the public was involved, it could prejudice the body's position in that litigation. It includes pending litigation, so matters where there is a substantial exposure to litigation, even if litigation has not yet been initiated. And it also includes discussions where the body's deciding whether to initiate litigation itself. Second, the personnel exception. The purpose of this exception is to protect the privacy of the employee and allow the body to speak candidly. And it can be used to consider appointment, employment, performance, or dismissal of a public employee, or to hear complaints. A third exception is the investment matters exception. And this exception allows closed session for certain bodies, including calPERS, those bodies that invest retirement, pension, or endowment funds, allows closed session to consider investment decisions. And the purpose behind this exception is to avoid compromising the value of the investment. Third, the health contracts negotiation exception. This exception applies to certain actions where a body's discharging responsibilities related to fringe benefits. For calPERS, it comes up in the context of health contract negotiations, and it permits those to be held in closed session. A related exception allows, and it's specific to calPERS, it's not actually general in Baggley-Keene, it allows closed session to discuss rates and strategy for long-term care plans. And then just briefly, the deliberative exception allows discussion on matters that are being considered under the Administrative Procedures Act. There's others, real estate, some other ones that I think come up less frequently for us. Those are the highlights. So I'm going to turn now
Excuse me,
to,
quick, the first slide on closed meetings, keep minutes, it said.
that's right. So there's a requirement that minutes be kept. To a large degree, those minutes are not going to be disclosable to the public, but they could at some point be disclosable. When the matter is resolved, they might be. It depends on what closed session exception and what's discussed. But there is still a requirement that the minutes be kept. And it's my understanding that that's our practice here at calPERS, and we do that quite religiously without fail.
I don't understand deliberations. Could you expand on that a little bit?
Yeah, so this, any decision under the Administrative Procedures Act, the body can deliberate on that decision in closed session. Gina, do you want to say more about that?
So that would be, for example, during the board meeting, we have the proposed decisions of the administrative law judges, and you have your board counsel to advise you. If you should desire, you could meet in closed session with your legal advisor to talk about those.
Okay. So we turn now to the rights of the public. State agencies are required to provide notice at least 10 days before their meetings. That notice has to be posted on the internet. It also has to be made available in other formats if requested by someone with a disability. In general, the notice has to include all items that will be discussed at the meeting. And it has to include a brief description of those items. Generally, less than 20 words is considered adequate for a brief description. The idea behind that is the description has to be clear enough to give the public a meaningful opportunity to decide whether they want to participate in the meeting. So it doesn't have to be a brief, but it can't hide the ball and be unclear so that the public can't really decide if they're interested in that issue. If something's not included in the notice, can't be discussed at the meeting. So the scope of the meeting is really limited by the notice. Now, in addition to the notice, you have to make available to the public, and we do this at calPERS for our board. We do it all simultaneously, but they are really separate requirements. You have to make available to the public all of the supporting documents that are provided to the body as part of as part of the meeting, a part of the issues that are going to be discussed at the meeting. So by way of example, of course, we provide our agenda items, which then inform the discussion that takes place at the board meeting. Those all have to be made available to the public. Generally, they have to be made available to the public when they're made available to the body. So you can't have documents that are considered by the body that the public doesn't have access to. Okay. I mentioned that you generally are required to give notice within 10 days of the meeting. There's an exception to that for special meetings. Special meetings apply to several specific situations, but they only apply to those specific situations if one of two other criteria are met. The body has to determine that the 10-day notice requirement would impose a substantial hardship on the body, or the body has to determine that immediate action is required. So you can't just call a special meeting because it falls in one of the categories for a special meeting. There has to be this additional hurdle satisfied of really a need to negate the 10-day requirement. There are a number of different reasons a special meeting can be held. I'll briefly mention a couple of them. Considering pending litigation, considering proposed legislation, issuance of a legal opinion, issuance of an audit, certain real estate purchases, disciplinary action involving a state officer. So there's quite a few reasons available, but again, there has to be that determination that the 10-day requirement will not work. Emergency meetings, there's a mistake on the overhead. They don't require 48 hours notice. Emergency meetings are very unusual. They're not going to come up in calPERS, but I'll just mention them briefly, that it's a work stoppage or other activity that severely impairs public health, or a crippling disaster that severely impairs public health or safety.